maybe they can enlighten you.
Yeah, here are the speakers. Both for, anybody in favor of this bill? Okay, and those against it, might as well line up behind that. Go ahead, come on in. Thank you.
I'm here for the Virginia Family Law Coalition, and we did do an extensive study with other groups, one of, or two of whom are here in one person just to talk about this. And we spent a tremendous amount of time trying to get the language right on this, and really do feel like this language does what needs to be done in this case and will achieve the results that are needed to make sure to protect these children going forward. So
If this is, say, after the first order, somebody comes in, change of circumstances, does this deal with change of circumstances? Or do you go back before the change, before the last order?
It could be either, because
Okay.
it is a history.
It's a broad.
So it is fairly broad,
It trumps, is what Senator Serval was saying, it trumps the rule that you can't go past the previous order.
Right.
Okay.
But really part of it, or much of it really, was about an intimate partner who may not be a household or family member, because that's one thing where we've been stuck to only having that
So
household or
it could
family
be
member.
somebody, a third party.
Right, it could be, well, it would be a person that there'd been a relation with, an
right.
intimate relation with at some point, but that the couple may have never lived together.
Right.
I mean, oftentimes couples get together, have a child, they never live together, they raise the child, they've been intimate partners, but they're not together at the moment.
Right.
And we do think that the language, as written now, is an
Better.
important
So you
bill.
support it?
We
Okay.
do.
All right, next.
Mr. Chairman,
Yeah, Senator McDougall.
just if she could come back, just
okay.
by putting on the limitations of intimate partner's child, are we then saying if there's an act of violence, which could be pretty substantial, that's not with one of those individuals, that we're not going to be able to consider that? So,
No,
because under the statute, under this section, because if we limit it, then I don't think we can, judge can't come in later and say, well, you stabbed somebody, but they were not an intimate partner or an intimate partner's child, so then I cannot disregard subsection 6 because there's a specific determination of when I can disregard subsection 6.
And we had looked years past and this year at something broader, and the reason that we don't want something broader, and I think we used this example a few years ago when something similar came up, is you don't want a man who is perhaps 39 years old today and has children and has been a model parent, model citizen, done everything right, great husband, but then there's a divorce situation and mom decides to bring up what she knows happened when he was 19 years old in a bar fight, to say you have to, you disregard this now because he got in this fight and there was an abusive situation of just a person. And it could have just been two grown young men, but two grown men, hurting, beating each other up, and then that becomes a reason that the court can make a different determination here. And so that we were trying to not make it so broad that it encompassed things like that, but really talked about family abuse, but it may be a situation where it's not a family in the definition under the code because the parties weren't ever married or they never lived together. But it takes out something like that. That can still be considered. It's just not a definite that it kicks the other section. It can always still be considered.
Senator McDougall.
And maybe Mr. Benjamin can help me on this. As I'm looking at that, I can also think of a hypothetical where somebody stabs somebody intentionally, but that person is not an intimate partner or intimate partner child, and the judge then cannot disregard subsection 6 because there's not a specific prohibition of doing that with an act of violence.
Mr. Chairman, Senator McDougall, I had the same or similar concerns, but I got there, and I want to make sure the witness hears me.
You listen to staff here. Listen to Steve Benjamin, our senator, extra senator. He's got a question.
Mr. Benjamin.
I wanted to make sure okay. The challenge here for me is the ambiguity of the phrase intimate partner. And I think that there will always be there can always be disagreement even between two people as to whether they were in an intimate partnership. And I don't really know what you mean here when you say intimate partner. Do you mean that this to include anybody with whom you have ever had a sexual encounter? Or by using the word partner, do you mean that there must be both a sexual encounter and a relationship that has blossomed into some type of partnership?
There would need to be some sort of relationship. This is not meant to be
That's what I
a
thought you
one-night
meant.
stand.
And so then my question becomes, at what point does an intimate relationship become a partnership?
Right.
At what point? And so as I wrestled through these same questions, I had the same concerns that Senator McDougal expressed, and I thought, why limit this to that difficult to define relationship called intimate partnership? Why not simply say against another? And I understood your answer earlier that you don't want to go back 40 years for a bar fight, but I think a judge would have the discretion to, wouldn't he, to ignore that kind of situation?
Well, but this says that they will, they're able to disregard it. We would want.
Able to.
Well, I think it actually says,
6, subdivision
may
6.
disregard. So it does, it's just opening it up that broadly, I think is going to, because this does allow people to go back. I mean, the issue is that would have someone be able to go back before the past order. When, let's say a situation is such that the couple is married, there's an order entered when they first divorce, it's going along okay, and then all of a sudden one spouse gets mad at the other, say the mom of the child gets mad, dad's done something to tick her off. So then she can go back to this bar fight that was ages before, when the dad has done nothing to her, to the child, everything has been fine, and bring that up again. And then that would give the judge that ability. Now, would he? Perhaps not. But it's just that's making it far too broad.
Yeah.
And we spent a tremendous amount of time on this study going back and forth on the right words to use. Is intimate partner perfect? Maybe not. Do we need to define it more? Perhaps. But a person would be a much bigger mistake, I think, than saying to us, you need to define it.
Mr. Chairman, my concern is that using intimate partner would create a substantial amount of litigation, much more litigation than if you simply said another.
Yeah,
That's my concern.
Mr.
You're
Chair.
always going to be fighting over whether it was an intimate partner.
Senator McClellan.
Mr. Chair, so under Code Section 32.1-283.3, we have required the Office of the Chief Medical Examiner to investigate family and intimate partner deaths and do a report every year. I have not been able to pull up the full code section to see if the term intimate partner is defined there, but there is enough of a definition that the Chief Medical Examiner knows what to investigate as to whether a death is related to intimate partner violence. So perhaps that can provide some guidance. If there's not a definition there, then.
Mr. Chairman.
Yeah, Senator Serval.
I think we felt that term was
Well-
self-explanatory enough that we really didn't think we were going to run into this problem because
It's a term that's used enough so people generally knows what it means, right?
right, exactly.
Yeah, Senator Serval.
Let me try a different spin on this, and a question for counsel, I guess. Assume for the sake of argument that Brett Kavanaugh was in a custody dispute. Could his wife call Christine Blasey Ford under this statute to come testify in the custody proceeding because she alleged there was intimate partner violence that occurred 20, 30, 40 years ago when he was in high school? I mean, would that be covered?
And drunk.
Yeah. That would be fair game under this statute,
She wasn't
right?
an intimate partner, though.
Well, they would say she wasn't in no, that was not a partnership, that was not a relationship.
Okay,
They contemplate a relationship.
Yeah,
okay,
Not just a one-night stand.
yeah.
Right.
okay.
Right.
Mr. Chair, I would also note that the term intimate partner is used in 18.2-308.2, :2, criminal history, record information check required for the transfer of certain firearms. We've used this term.
It's been used before.
In the code. It's used enough that every single year, the chief medical examiner's office knows what type of death to look at as intimate partner deaths to report to the General Assembly. We were comfortable enough using the term to require those reports. So I think it's a term of, it's a common enough term that the judges will know what they're supposed to be looking at.
That was the conclusion that we
And again,
came to in
these are,
this study.
and again, these are things they can consider. These are not things that in and of themselves, by themselves, will necessarily determine the outcome.
Right. But it was,
Miss-
it was something that was missing.
Mr. Chairman,
McDougall.
Mr. Chairman, I think Senator Serval's issue and mine were different. My issue is that when you limit this to intimate partner or intimate partner's child, there can be an act, force, threat, or violence as defined as 19.2, 152.7.1 against another child or another individual, and that now is not going to be able to be considered as a factor that can disregard subsection 6. So y'all are very much focused on the intimate partner piece as being inclusive, but when we put it in here, it is also exclusive because we're listing out specifically what we can look at, and it's not acts of violence against another child that's not an intimate partner's child or another individual that's not an intimate partner.
But again, it's just that the court may disregard it. They don't have to.
Well,
It
Mr.
is a
Chairman,
may.
but the concern is now we have a specific item that talks about acts of violence, force, threat as defined, and, you know, the definition is any act of violence, force, threat that results in bodily injury or places one in reasonable apprehension. So if we have one of those acts against somebody else, then the court could look at this and say, well, now I can't disregard subsection 6 because there's specific guidance when I can disregard subsection 6.
Well, Judge, but subsection, I'm sorry, I keep calling everyone judge because that's what I'm used to saying, but
Not a
6
single
is
judge
just,
here.
6 is just the propensity of each parent to actively support the child's contact and relationship with the other parent, including whether a parent has unreasonably denied the other parent access to or visitation with the child. So that is a very specific section as well. And it's only talking about whether, okay, if, let's say there has been this violence, and one parent, until you get into court, has kept the child away. So the court can look at why they did that. So it's not a custody determination just from those two sections alone.
Mr. Chairman, if the allegation is that they had used force or violence or threat against another person's child, I don't care if it's an intimate partner's or not. I'm not going to let my little girl go around them until the court tells me I have to. So why are we saying that a parent, and that's the point I'm getting to, if you put in just intimate partner, why can't we take that section out and leave in the violence, force, threat, and then leave in the child and the history and take away the intimate partner, because it's very limiting.
We just really feel like opening it is far too broad. I mean, we want to limit it somewhat in this. Having it broad concerns us more than having it narrow in this instance. Because
Okay.
again, these are just the factors that can be considered. And that one is, section 6 is just saying whether it's a problem that the child has been kept back for that amount of time and denied access.
Okay, anybody else want to have any questions? Anybody else would like to speak?
I have one more speaker.
Yeah, oh, good, one more speaker, okay, good.
I'll be quick. Sushila Varkey from Virginia Poverty Law Center. We, as well as Jonathan Iglesias and others from the Action Alliance, were part of this group that Kim mentioned. So we're happy with the language as is for the reasons stated. Thank you.
Okay, is there a motion? Moved and seconded to report. Any discussion? With the amendment, line amendments, and does it have to go to finance? No?
No.
Okay. It's moved and second to report with amendments. All in favor of the motion, say aye. Record your vote, aye. Opposed, no. The clerk will call the roll. Ms. Herbold, you were absent? You're not absent. Abstaining, okay. The clerk will close the roll. Okay. Ayes 5, noes 2, abstention 5. So did it pass? It reports with 5 votes, 5, 2, and 5. Okay, good luck.
I guess there'll be a robust conversation on the floor. Well, okay, and I have another bill which I think will engender just as much conversation. It's Senate Bill 179. Are you
Yeah,
ready
179.
to hear that, or?
Yes, go ahead.
Go ahead.
179.
Okay, this is a hate crimes bill, hate crime statute, and what my bill does is it adds to the definition, excuse me, there is a line amendment, or,
Okay, line amendment.
the substitute in,
Okay. And that is no
amendment in the nature of a
all right.
substitute.
Okay. Okay. Is there a motion to adopt the substitute? Second, moved and seconded to adopt the substitute. All in favor say aye. Aye. All opposed, no. The substitute is adopted. Okay, Senator Favola, explain the bill.
Okay, so this bill expands the categories that would be considered under a hate crimes law to add gender, disability, gender identity, sexual orientation, or or sexual orientation. So what we would be doing is tracking the federal law by adding those categories. And we also define disability. And by the way, 32 states have added the phrase disability to their hate crimes bill, but they have not defined it. We have. The bill provides for civil action. The bill also provides for liability for defamatory material on the internet. These sections are already part of our current law. Again, I'm just adding additional categories. And then we have an assault and battery section. In the substitute, I removed the minimum of 30 days, both on line 53 and line 57. So if an individual I want to say convicted. If an individual is convicted, then a minimum term of 30 days would be removed, but the person would be considered guilty of a Class 6 felony, and a judge could determine the jail sentence of at least 6 months or more. And I'm trying to find all the, and that was line 57 and 58.
Class 1 misdemeanors a year.
I'm sorry?
Class 1 misdemeanors, 12 months in jail, unless it's changed here.
Mine says 6 months.
Class 1 misdemeanor, where did it say that? Oh, okay, I'm looking at the assault and battery penalty here.
Mr. Chairman?
Class 1, where are you now?
And then there is a reporting requirement as well.
Okay, all right.
Mr.
I
Chairman?
see. So it goes from Class 1 misdemeanor, then it goes over to Class 6 felony. Okay. All right, yes, Senator.
Mr. Chairman,
yes, Senator
this is
McDougal.
for Mr. Benjamin. Mr. Benjamin, when I'm looking, I guess, at lines 51 and 52, so and this is what we're talking about, where so when we say a term of confinement of at least 6 months, that means the minimum has to be 6 months. Can the court suspend all that, or?
Yes,
Okay.
Mr. Chairman, yes, he can.
So, Mr. Chairman, with the substitute, we're saying that we're adding more to the list for which you can be convicted, but we're not saying that we're reducing the amount of mandatory confinement from the list that already exists.
That's correct.
That's
Okay.
What is the?
Again, the
cla-
governor had come out with a policy statement on not supporting minimums. That's
Chairman,
where I went.
But
you,
I voted to override, I think, one of those bills relating to domestic assault, multiple cases, so I might have a different opinion.
okay.
What is the time for a Class 6 felony?
Up to 1 to 5 years in the penitentiary.
Okay, and this one says the penalty should be 6 months, not 1 to 5 years.
No, it says it must
At
be
least.
at least
At
6
least.
months.
Penalty, okay, but that can be suspended.
It can be.
Yeah, okay.
And I was advised, and these very egregious hate crimes can be referred to the federal government, and when they prosecute, they clearly do have minimum requirements, minimum jail time, and
Happened in
other,
Charlottesville recently, didn't it?
yeah, and other tools in the toolbox. So I do have speakers. I'm trying to keep my comments limited. I can tell you why this is really important, and the fact that hate crimes have been increasing, and it's really important to send a message to all Virginians that everyone is valued and will enjoy equal protection under our laws. I will ask my speakers if they want to come forward.
Okay, who's speaking in favor of Senate Bill 179, the substitute to Senate Bill 179?
Good evening, Mr. Chairman. Colleen Miller from the Disability Law Center of Virginia. We do support this bill, and we're really appreciative to the senator for her persistence in this. The extra protections for people with disabilities would be much appreciated. Thank you.
Okay, thank you. Okay,
Good evening, Mr. Chairman, members of the committee. My name is Andy Elders. I'm the Deputy Public Defender for Fairfax County. In speaking with Senator Favola about the original bill, expressed our concern that as written, it would significantly expand the class of crimes that would be subject to mandatory minimum sentences. Our opposition and our concern about mandatory minimum sentences, broadly speaking, led us to raise this issue, and I think led to the adoption of the substitution. We're appreciative of that.
the mandatory minimum has been taken out.
Yes, sir, that's correct.
right.
That it would have expanded the 30-day mandatory minimum to an entirely new class of crimes, and that was the reason for the
But you
for the
support it now?
substitution. We do. Thank you, Your Honor.
Okay, thank you.
sir.
Public defenders support it. Okay,
Well, this is Scott Emery from the AG's office.
that's correct.
So
Attorney
you
General,
might
okay,
hear a different view.
go ahead.
That's correct. Good evening, Senator Edwards, members of the committee. I'm Scott Miles. I'm here on behalf of Attorney General Herring, who was prepared to support this bill in its original form. I noted as I reviewed the bill, it doesn't create any new crimes. It doesn't expand the 2 existing criminal statutes that it addresses to capture additional behavior. It doesn't alter the structure of those statutes, which has been the same for decades now. And what it does is add these classes to the structure that's been in place. And so for that reason, the Attorney General is going to support it. However, in its current form, he opposes it. And the reason is this 30-day mandatory minimum. Now if somebody attacks somebody else because of their race or their religious affiliation, they know they're going to jail for 30 days. And that's an important component of the existing law, without which we're rolling back protections for these 4 classes. And what I noticed is that hate crime is a persistent problem in the Commonwealth. As I reviewed the statistics that the Virginia State Police publish every year for us, what I see is the 2 largest categories of victims of hate crimes are people who are targeted for their race and their religious affiliation. So we view the removal of the 30-day mandatory minimum provision of these 2 criminal statutes to be a weakening or a rolling back of protections that have been in place for a long time. And for that reason, the Attorney General opposes the bill in its current form. One additional note is that I've been in a position of trying to refer cases to the federal government for prosecution before, and that's not a certain thing. Feds don't always take a case, and they have their own analysis for why they will or won't accept a particular case for prosecution. So I suggest that it's hazardous for us to rely on the federal government to do something as a reason for us not to do it. Thank you.
Well, let me ask you this. It takes out, which should be mandatory minimum term of 30 days, but it leaves in the sentence should be at least 6 months.
Yes, sir. The 6 months, as you pointed out, is suspendable, subject to suspension by a judge.
Wouldn't the governor, at the veto session, send down an amendment to get rid of the mandatory minimum?
This is a mandatory minimum that's been in place for a couple decades, I think.
I
I saw a
understand, but-
reported opinion from 2003 addressing the laws that existed in 2000. So this doesn't create an additional mandatory minimum, which I understand the governor has committed to vetoing, but that's not what this bill would do in its original form.
Okay, all right, thanks.
Thank you.
Okay, next. You for or against the bill?
Opposition.
Okay, opposition, here we go.
Eddie Aliff, Virginia Assembly Independent Baptist. First of all, we feel like all crimes are motivated by hate. And so if we are going to treat everybody equally, then kind of everybody should be listed in here, but not trying to be, that we don't want to take care of certain things. Our biggest problem is that sexual orientation and gender identity are not defined. They define disability. I don't see those, and from everything that we've heard in conversations is these are pretty broad and kind of changing. They're very changeable. And if you're going to put something in law, I think it should be something that's pretty definitive, and that would be our biggest concern of adding them in without giving clarity. Thank you.
Next.
Good evening, Josh Hetzler with the Family Foundation. Members of this committee are no strangers to hate crimes legislation. I know this comes up every year. But I want to remind you just of the two overarching principles with which I think we should all agree that sort of militate against the idea of hate crimes. And the first is that the government really shouldn't and really doesn't have the authority, constitutional or otherwise, to criminalize, to penalize thoughts, which is what these do. I mean, think about it. It's the difference between having a misdemeanor for an action that could be up to a year in jail versus a felony, which could be up to 5 years in a federal penitentiary. And the only difference between the two is that some types of thoughts that motivated a person to commit the same act was disfavored by the government, right? That's a problem. And the second principle is that, of course, if the state has the power to penalize, to criminalize some thoughts, then there would be no limitation for it to do so for any thoughts. And, you know, that may be, we may all agree on them today, but tomorrow there may be someone new in office, right? And so I would just encourage you to think about this from a long-term standpoint. Set aside the actual issues that are being added. I know it's well-meaning, and we all want these heinous crimes to be penalized, no question. But I want you to think about the unintended consequences. So I would urge you to oppose this. Thank you.
Okay. All
Mr.
right.
Chairman?
Senator
Well,
Ferrell,
again,
yeah,
I
Senator
would just-
Morrissey.
I got a question of the, Josh.
Josh.
You mentioned a moment ago that we're penalizing thoughts. Just, can you direct me to that portion of the bill, the line where you feel it's penalizing thoughts?
Let me see the substitute. Find the line. Is this not in the hate crime section?
Were you talking about?
Oh, so if a person, I guess I'm referring mostly to line 54, 55. You might say that, well, this already exists and it already, well, I would say I disagree with the additional penalty on the basis of thoughts or motivations. And I think we shouldn't expand it.
Okay. All right. Thank you. Any other questions? Anybody else like to speak in favor or against the bill? Senator Ferrell.
Mr. Chairman,
wrap it up.
I will just say that these categories that I'm expanding to have been in the federal statutes for 10 years, and they have really endured the test of time. And when prosecutors are asking for additional penalties, if you will, for a hate crime, they actually have to demonstrate with evidence and facts that this crime was motivated by hatred of a certain group of people because of who they are. It's not a willy-nilly, well, you know, gee, I think we'll just apply the hate crime statute. this statute has been applied in cases that are very egregious, and I can go through those cases, but I don't think it's the pleasure of the committee to hear any more testimony. I think you
Okay.
probably understand exactly what this bill does, and you either are going to agree or disagree. If there's any middle ground here, I'm happy to try to find it. I have not been able to find the
Like
middle
we're ready to-
ground between having a minimum requirement
We're
or
ready
not
for a
having.
motion. We're ready for a motion, I think. We got a motion? Okay. Yeah, it's got to go to finance. And,
So moved.
all right, it's moved and seconded that Senate Bill, what's the number again? 179, the substitute to 179, be reported and re-referred to finance. All in favor of the motion, vote aye. All opposed, vote no. Okay, is there, all right, clerk will close the roll. 8-3. The motion passes by 8-3, and the
Thank you.
bill is referred to finance and reported.
Thank you.
Mr. Chairman.
Okay, Senator Shervill.
Mr. Chairman, Senator Saslaw moves, and I will second to reconsider the vote by which we move to report Senate Bill 105 and speaking to that motion.
All right, Senate Bill 105, which is Morrison's bill.
No,
No, I'm sorry, which bill, whose bill is it?
Senator Favola's bill, and I
Okay,
told her I was
okay,
doing
Senator
this.
This is the best interest of the
Yeah,
child.
5, 2, and 5. Okay, it's been moved and seconded that the Senate bill, the vote by which we reported was a substitute Senate Bill 105, be reconsidered. All in favor of the, is this a voice vote? You know, we got to
No.
voice vote. All in favor of reconsideration, say aye. Aye. All opposed, no. Do we have to vote? I'm sorry, recorded, I'm sorry. Vote aye. All opposed, vote no. Okay. The bill, John? 11-0. All right, it's been reconsidered by a vote of 11-0.
Mr. Chairman.
Senator Favola, I mean Senator Shervill.
Mr. Chairman, I move to PBI the bill, and Saslaw, Deeds, and Peterson second, and speaking to that motion.
Could I,
Yes, Senator Favola, your bill.
could we pass it by for the day so I could possibly work on it and
Without
maybe come up with a
objection,
definition?
Without
Okay.
objection, the bill will go by for the day.
Thank you.
Okay.
Thank you, Mr. Chairman.
Any other bills that we need to look at? It's only 6:36.
Mr. Chairman, I have people here from Prince William County on my bill, which I think will be quick.
Oh, okay. What bills?
Do you represent Pennsylvania County? Or Prince William? I thought he said Pennsylvania.
I'm 72.
All right, Senator Marcy's Senate Bill 815 will be sent to Criminal Law Subcommittee. All right.
I'm 72, Mr. Chairman.
I know that, but we're doing another.
Okay.
Senate Bill 1, what is it, Senator Marcy's marijuana bill, we go to Senator Deeb's Criminal Law Subcommittee, right? 815, all right? Senate Bill 815 will go to the subcommittee. Okay, Senator Shervill. What's the number of the bill?
72, sir.
72, okay.
Senate Bill 72 would authorize the creation of the Public Defender's Office in Prince William County, the City of Manassas Park. It's a very simple bill. There are 25 public defender's offices
Yep.
in Virginia. We have not created a new one since 2004 or 5.
Okay.
Prince William County is the second largest jurisdiction in the Commonwealth, especially when you add Manassas Park. It's super big.
Yeah.
The bill, the funding for it is in the governor's budget, and there's a bunch of there's a couple folks here, I think, that are prepared to
And
testify
all
for it.
speaking in favor of the bill, I saw you earlier today. Thanks for coming. Step right up. Sorry you had to wait.
It's okay, Mr. Chairman and committee. Thank you. I'm Reverend Dr. Keith Savage. I'm one of the clergy leaders when Virginians organized for interfaith community engagement, known as Voice. We totally support this bill. It is long overdue, as Senator Shervill said. It allows us to bring equity into Prince William County, the City of Manassas Park, being the second largest jurisdiction, the only mega court jurisdiction that does not have it. We have spoken on the ground with hundreds of individuals. The one thing missing is allowing for equity and not relying solely on a court-appointed system. Financially, it's not as big a hit as it is. The governor has put the money in his budget, but most of that money that is needed for this is going to be shifted over from the Virginia Supreme Court, so you're really looking for a small amount, but more importantly, it brings about social justice. It brings about the equity of having proper representation on both sides of the aisle. The Commonwealth Attorney in Prince William County supports it. The majority of the Board of Supervisors in Prince William County support it. And so we believe that this is the right time, it's ripe, it's necessary, that this would go forward.
How many people live in the cities of Manassas Park, and the county of
There are
Prince
over
William?
400,000 residents.
Yeah, the Prince William surrounds Manassas, right?
That's correct.
400,000, and that includes Manassas.
Yes.
And I'm surprised you
Well,
don't
no,
have.
it's just
No,
Prince
Prince
William.
William's about 415,000, Manassas is about 40 or 50,
50.
and Manassas Park is about 15.
So almost 500,000.
Okay, I'm surprised you don't already have one.
So are
Okay.
we.
Yeah. Okay, anybody else want to speak in favor of the bill?
I'll just note the Maria Jankowski is the head of the Public Defender's Service.
Yeah,
Bill
yeah,
states
we-
here to answer any questions if
Yeah,
necessary.
Maria, would you like to say something, anything?
Only if you've got some questions.
Okay, no any questions? Is it a motion to report and
Mr. Chairman?
re-refer? Yeah.
I do have a question
Yeah,
for
okay.
Maria. Are there,
Senator McDougal.
are there any studies or empirical data to suggest that a court-appointed attorney gives a different or less representation than a public defender attorney?
Not recently in Virginia. There were some studies, and it's been a while back.
In Virginia?
Yeah, it's been a while back that showed that some of the outcomes that the public defenders got were better, and there's some national studies, but there is nothing recent and there's nothing in Virginia.
All right, any discussion? Is there a motion?
Second.
It's moved and seconded that the bill be reported and referred to finance. All in favor of the motion?
Does it have to go to finance if it's in the budget, governor's budget?
Yeah.
Okay.
All in favor, vote aye. Serval hadn't voted yet, so we'll wait until he does so. And any other, where's everybody else? Clerk will close the roll.
Ayes 9, noes 1, one abstention.
Okay, 9, 1, and 1. All right. Yeah. Okay, Senator McClellan. If anybody else got a simple one, that'd be fine too. No, Senator, this is 3?
Yes.
Okay, good, yeah, get this one done.
I have a substitute, but before we adopt the substitute, I want to explain the bill and
Right.
the substitute. So this is a bill we saw last year. It passed the Senate with only 2 no votes. That would have eliminated the misdemeanor charge of disorderly conduct at a school or school-sponsored event, which is currently found in subsection C of the disorderly conduct statute. The Commonwealth Attorneys Association had some concerns with that bill about the ability to charge parents who might engage in disorderly conduct. And so working with them, and we have come up with a substitute that alleviates their concerns, that rather than eliminating the charge altogether for activities at a school or school-sponsored event, it would carve out students from the disorderly conduct statute. The problem that we're trying to solve is that there are a lot of students who have been charged with this misdemeanor for activity that is not criminal, should be and used to be handled by the disciplinary process, including, I think the most egregious to me was a child that was charged with the misdemeanor for singing a rap song on a bus. Got many more examples I could
Were
give
they
you.
singing out of tune or what? I'm
I
kidding.
think he just was annoying to the bus driver, I don't know. But if there are any questions on this, this pretty much sailed out last year, slight different this year, which is why I wanted to present the bill before adopting the substitute to see if there were questions specifically on the substitute and if the committee preferred the original bill.
Mr. Chairman?
Yeah, Senator McDougal.
The elementary school is good, but secondary students, so you could have somebody that was 19 or 20 from a different jurisdiction going to a school that they do not attend, and now they would not be able to be charged. Is that accurate?
This would not apply to any elementary or secondary school student,
Mr. Chairman?
as I read it.
Yes.
Well,
Senator
I
McDougal.
guess my question is, you
Yeah.
could have a 19 or 20-year-old that is from Prince William, and they decided to show up at a school event in Richmond, and there could be, and now they cannot be charged for activity that occurred on that school. So this,
They could not be charged solely with disorderly conduct, correct? The way I read the substitute.
But, Mr. Chairman, they could still be charged with other offenses such as trespassing. If
but
they came.
Mr. Chairman, if
Yeah,
they were
Senator McDougal.
at a school-sponsored event for which they had not been previously barred, then they could not be charged with trespassing.
Correct, but if they did not leave when they were asked to leave, then they could be charged with trespassing. And if they committed a crime such as assault, they could be charged with that. They simply can't be charged with disorderly conduct.
Well, Mr. Chairman, I guess,
Yeah, Senator
I
McDougal.
don't want to belabor this too long, but if a person is at a school event that is open to the public, what say a sporting event, football game, and they're not from that school district, what authority does the school have to tell that person to leave if they're just being, that conduct which is disorderly, which traditionally involves some sort of alcohol?
Let's hear some examples, I guess. Maybe that's what we need.
So,
Well,
Mr. Chairman,
Mr. Chairman, to answer that question, I mean, disorderly conduct is any conduct that has a tendency to cause acts of violence. And so if a student is at a football game and is engaging in that kind of conduct, then I am certain that they could be asked to leave. And if they committed, if their conduct was assaultive, then under existing law, they could not be charged with disorderly. They would have to be charged with assault or assault and battery.
Maybe we could hear some
Uh,
testimony.
Yes, someone from the School Board Association.
Mr. Chairman, I had a quick technical
Senator-
question.
Yes,
Let her
Serval.
answer.
Senator Serval.
I had a client recently who was charged with disorderly conduct for hiding under a school bus seat in 7th grade. And I wanted to know is a middle school, in Fairfax County, we have middle schools. Is middle school an elementary school or a secondary school? It is secondary?
Secondary.
Okay, I just want to make sure of that. Okay.
Okay, yeah, go ahead, yes.
Mr. Chairman, Stacey Haney with the Virginia School Board Association, if I could address Senator
Yeah, please
McDougal's
do.
question
Uh-huh.
regarding asking someone to leave. And I mean, I've litigated this issue. The school property is not property that's just open to the public and anyone has the right to come on. So the school board or its agents can and often do, issue no trespass orders. So certainly the school principal or whoever, is present at the football game or whatever has the authority to ask someone to leave. And if they don't, I believe that then they would be, could be charged with trespass.
Mr. Chairman.
Yeah, Senator McDougal.
And we only just got substitutes, so I'm just trying to skim through it. So if we are talking about a football game, that's a school activity, but what if you're talking about another group that has rented out the school to hold a function, and a secondary school student comes to that function?
This would only apply.
It's only to,
school-sponsored events.
It only applies to school students.
is that right?
Yeah,
Steve?
yeah.
Steve, is that?
Okay.
That's correct. It doesn't apply to any student for conduct that occurs at an activity conducted or sponsored by any school.
Mr. Chairman,
Yeah, Senator, Boysko.
a question for the patron?
Yeah, please.
Are you trying to get at the decriminalizing students' behavior? I know that when I was in junior high and high school, kids misbehaved, and it was the principal of the school and the administration who managed the discipline. Now we are seeing children having the police brought in and actually criminalizing their behavior
I think
for
that's
things
it.
that would never have happened when I was in school.
Yes, and it's for behavior, it is for behavior that if it was anywhere other than at a school or school-sponsored event today, it wouldn't be a crime.
What
But
it would,
it would not be a crime. But because it occurs at a school or school-sponsored event, it is captured under the current Section C as written, which is very broad, which is very vague, and has led to kids being charged with a misdemeanor for running with scissors, someone who got an autistic child who got a schedule change, flailed around, charged with a misdemeanor. A kid who was sent to the principal's office, also autistic, got upset, on the way out, kicked a trash can, charged with a misdemeanor. That is what we are trying to address.
Okay, let's hear some more testimony. We heard the School Board Association support it. Yeah.
Yes, I'm sorry, Mr. Chairman, I didn't say that when I was answering the question, but we are in support of it.
And you're in support of it
Because we want to reduce instances of our students being charged with these misdemeanors.
and the school board can handle this conduct.
Exactly.
Yeah.
These are offenses that can be handled through the normal disciplinary processes.
Okay, thank you. All right, next.
Mr. Chairman, Amy Woolard with Legal Aid Justice Center, and we're in support. Under current law, a student can recklessly create a risk of annoyance in disrupting any school
That happens pretty often,
operation
doesn't it?
or
Annoyance.
activity and be guilty of disorderly conduct,
Yeah.
basically, if an adult says they are. We see these time and again also sort of co-charged with a disciplinary suspension. So you have kids who are suspended for the same behavior that's getting them a criminal charge. And we had a client, for instance, who had such a suspension, went before a judge on the disorderly charge. The judge said, I'm gonna take this under advisement, but you have to go to school as a condition of your charge getting dismissed, but the kid was under suspension. So we see these things kind of operating to double punish kids in ways that spiral and push them out of the building. I would just sort of underscore, Senator McDougall, there are many, many other charges that generally can be and are used when the behavior becomes more serious. And
Mr. Chairman,
Senator McDougall.
I don't want to misunderstand what I'm saying. My concern is if you're talking about in the jurisdiction for which the student attends school, so if you're talking about the city or the county or the town, I am much more comfortable about this. But right now, the way this is written is if you are a student and you go somewhere else, you could be a student from California and be 20 years old and in high school in California and come to a jurisdiction, and then you would have a specific exclusion. So that's what I'm trying to ask, if there's a way to tighten that portion of it up, because I understand what you're saying for that portion.
Mr. Chairman,
Yeah.
Senator McDougall, I would just say, I think we're just trying to address the level of behavior too here, and if it's at this sort of disorderly conduct level as opposed to some other kind of offense, should we be criminalizing that behavior for this group? I think is where we're coming from. I hear what you're saying.
Okay, was the legal aid involved in the criminal matter?
Mr. Chairman, we serve clients who are involved in school discipline matters that
Okay.
often get intertwined with
Right.
their
Okay.
delinquency charges and
Okay.
complicate
Okay,
matters.
all right, thanks. Next.
Good evening, Mr. Chair, members. My name is Marissa Boyce. I am an assistant public defender here in the city of Richmond, and my practice is localized in the Juvenile and Domestic Relations Courthouse. So I represent children on a regular basis. And I will tell everyone that I represent children charged with disorderly conduct on a regular basis. I would tell everyone that, in fact, yesterday I had a juvenile client who was charged solely with disorderly conduct. The incidents that led rise to his arrest is he tried to get away from the security guard and stepped on the cafeteria table during a lunch period.
That's terrible. This is awful. I'm just kidding. Go ahead. I'm interested in hearing these stories.
Yes, the security guard pursued him to the other end of the cafeteria, tackled him, got him on the ground. All of this was captured on footage. I believe it's a body-worn camera. I saw all of this myself with my own eyes. And this child, who all he had done was just trying to get away from these security guards for one reason or another, had to be served with this paperwork. He had to take time off of school to go to court to get arraigned. He had to return back for his initial date. He was not competent to stand trial, so we had to ask for competency. We had to go through a restoration period that involved weekly or bi-weekly tutoring sessions that are approximately an hour in length. We came back then, he was found competent, then we set it for trial, and then at the trial date, the case was taken under advisement. He was placed on case management supervision, which is, again, another level of supervision, another obligation that he and his family have to undertake. And then he comes back, I think at the end, it had been about 9 months that he had been court involved because he had tried to run away from a security guard. These are situations that should be dealt with in the school, as the school board is here saying these should not be criminal matters.
Why are these happening? These kinds of things happening? I mean, well, when I was younger, the principal handled all this stuff. Of course, that's many, many ages ago, but.
I'm not sure. As Ms. Willard said, there is a lot of overlap here between the civil and the criminal side when it comes to education and court-involved youth. I will say that it is something I see regularly. It is something that tends to come around in my experience when someone they're running away from a security guard, they're swearing at someone, there's been a fight and someone yelled, "Yeah, go get him."
Yeah, okay, well, thank you.
Thank you.
Next?
Mr. Chairman.
Yeah, Senator Morrissey.
Thank you.
Yes.
If I could ask you a couple of questions. It seems like to me that the genesis of this bill was to prevent overcharging a child in a school by charging him with a criminal offense for what otherwise, as the chairman said, would normally be handled by the principal. Is that right?
I believe so.
Okay. So you gave example, and you gave a long example of somebody who committed a rather minor offense, and I have seen scores of them where the person should not have been charged, okay? But this bill seems to say, if you engage in an act in a school that tends to cause violence, you can't be charged with disorderly conduct. Would you agree?
I need to review the.
Mr. Chairman, that's correct.
Is that what you intended to do?
That's correct.
Is that, okay, I'll ask you or the patron, is that what you intended to do, irrespective of the disruptive act that tends to cause violence? That person cannot be charged with disorderly conduct.
So the problem with the way disorderly conduct is now, the short answer is yes, because for pretty much anything, there are many other code provisions that for more serious activities, a student could be charged with. The problem that we have had is twofold, and to partially answer the chairman's question at the same time. The kids that are disproportionately being charged solely with disorderly conduct are students with disabilities and students of color.
I agree.
Now, I'll take the students with disability. Part of what we are seeing with students with disabilities is their behavior. Usually they are being charged because someone is attributing to that child a brain development. First, I'll just take a regular, not a student with disabilities, but any child, their brain development is different from an adult. Their reactions are going to be different. When that child has a disability, even more so. And so for activity that would not be a crime if conducted anywhere other than at a school or school-sponsored event by a student, if they did it in their neighborhood, the exact same act, if you do it in the school building, you could be charged with a misdemeanor. If you do it in front of, in a library, maybe not. So that's what we're trying to get at, is see, the original bill, and this is why I haven't moved to adopt the substitute yet, because I'm trying to get the temperature of the committee. The original bill eliminated C altogether, because we said it makes no sense from a public policy perspective why an act that you commit at a school or school-sponsored event is a crime if you did the exact same act somewhere else and it wouldn't be. That was the original bill. That's the bill that passed the Senate overwhelmingly. The Commonwealth's attorneys have concerns with that. The Commonwealth's attorneys want the ability to charge an adult who does something under C at a school or school-sponsored event. And so they weren't comfortable eliminating C altogether. So we did the substitute to address their concerns. I leave it to the will of the committee, because my concern is I do not want a kid being charged with a misdemeanor solely for singing a rap song on the bus. And that's why I brought this bill last year. That's why I brought it again this year. And if the committee prefers the original bill, I'm happy. If the committee wants the substitute, I'm happy, because either one solves my problem.
Mr. Chairman, so the substitute keeps, I'm holding that keeps in C3. This is the substitute, is that right?
This is, yes.
Okay. All right, final question.
Yeah, Senator Morris.
First of all, I don't have to be sold on the fact that the children are overcharged. Don't have to be sold on the fact that children of color or people with disabilities are either charged or disproportionately charged. I'm already there. I just want to be clear that with the situation with, I'll go the other way, the 240-pound offensive tackle on the football team who engages in conduct. He has no disability at all, but uses offensive language, gay slurs, on down the line. Is that person excluded now from being charged with disorderly conduct?
Under the substitute,
And is
yes.
that what you want to accomplish? I just need to.
There's another option here.
Yes, Steve.
Because the disorderly conduct statute speaks of conduct that might incite violence. But what the concerns I've heard about are the concerns about current subsection C, where it doesn't require conduct that incites violence. Instead, it could be conduct that just disrupts the operation of school and interferes with the orderly conduct of school. And so the option, the third option, would be if that subsection C, if that's your sole concern, then on the substitute, on line 34, instead of saying the provisions of this section, which reaches conduct that might lead to violence, you would say the provisions of subsection, and now it would be 3 under the substitute, and that's the current existing C, don't apply to students. And I'm just telling you that's a third option, so.
Mr. Chairman, based on this, we will take this by for the day. I will confer with my client and the Commonwealth's attorneys.
Let's hear if there's any other comments. The Commonwealth's attorneys have anything to say? You're the only one, I think, who has not spoken. Let's get all the speaking out of the way.
Mr. Chairman, Mike Doucette, Executive Director of the Commonwealth Attorneys Association, and we did approach Senator McClellan about some of our concerns dealing with parents. One of the questions that the chairman asked is why is this a problem now when it wasn't a problem when we went to school? And
I'm even a lot older than you, so go ahead.
Maybe not all that older. I mean, I started elementary school in very early 60s. Principals took action. Principals weren't afraid to yank Johnny out of the chair and put their hands on Johnny. I remember specifically my 5th grade teacher pulling a kid out of the chair by his hair and
We didn't think 2 seconds about it.
I saw a few things.
Nowadays, with SROs and police officers in schools, the SROs are being dragged into the disciplinary process by the school administrators because they have no other way at this particular point in time. Kids don't fear the principal anymore. When we went to school, we did not want to go to the principal's office. That was a scary place to go. Kids aren't afraid of that anymore. So now they're resorting to the SROs. When I was Commonwealth Attorney in the city of Lynchburg, we had regular meetings with our SROs saying, you will not get dragged into the disciplinary process. You only get involved if there's a criminal activity going on, and then you engage in stopping the criminal activity. But don't be looking to do disorderly conduct as a way to get into the disciplinary process. The problem, though, is SROs rotate out. And the new guys come in and they say, well, we've got this disorderly conduct provision here that says disrupting school activities. I'm going to exercise this because the principal has asked me to get involved with it. Our concern with Senator McClellan's original bill was dealt with the adults, the people who come to, the parents who come to the school, they come to the football game, they come to wherever it is. And one of the questions that was asked by Senator McDougal as far as the school football game, the school sporting activity, in a prior life, I was also a soccer official. School activities, sporting activities, all have field managers. They must have field managers who are responsible to make sure that in those situations when parents act up or whoever acts up, they are tossed at that particular point in time. And so there are people there who are designed to make sure that these activities are conducted in a peaceful and orderly fashion. So again, with Senator McClellan addressing our issues as far as parents are concerned, we support the bill as, now again, is it perfect? No. But it goes a long way towards solving what has been a huge issue of school resource officers, law enforcement officials getting involved in the school disciplinary process.
So in other words, you Commonwealth Attorney Association supports the substitute Senate Bill 3 because the parents are not involved.
That's correct.
Parents are out of the bill.
The parents have been removed from the bill.
Okay. Yeah, okay, I'm sorry.
Good evening, Colleen Miller from the Disability Law Center. We are supportive of the spirit and intent of the bill, and we look forward to seeing whatever kind of compromise gets worked out.
Okay. Okay, so where are we? You still want to?
I am going to take it back for the day so that we can discuss the suggestion made by Mr. Benjamin and see if we can address any of the other concerns raised. But again, I think you know what we're trying to do. And the last thing I will say, because in fairness to the schools, a big part of what is happening is there used to be a lot more people in the school building who could handle behavior issues. A lot of them are now gone. A lot of them are now gone because of budgetary constraints and things that used to be handled by mental health professionals or extra assistant principals.
Okay.
They're not there anymore. And unfortunately, that has put more pressure on SROs to deal with this through their work rather than through the disciplinary process. And so it's a big combination of factors, but who gets punished by it long-term are the kids,
Right.
who are just being kids.
Yeah, that's right. Okay, thank you all very much. The bill will go by for the day. Senator Searle has about 10 other bills, no, at least one.
247, that's 60 seconds.
60 seconds, by the clock. Go ahead.
Senate Bill 247. All the bill does is in the no-fault divorce statute replaces the word husbands and wife with parties to the marriage.
Is there any objection to that? All right, is there anybody to speak for it or against it? Or speak against it? Okay. Speak against it.
Okay.
All right.
Jesus.
Very, very brief.
That's okay. Yeah.
Josh Setzer with the Family
Sure.
Foundation. I'll just echo my comments from earlier about the nature of marriage and how I feel about that. And I'll say that words matter, and husbands matter, wives matter, and we think it's good that the law reflects that. Thanks.
Okay, all right. Is Baptist? That's all right. No, yeah, okay. All right, is no more, any questions? Is there a motion?
Second.
Any discussion? All in favor of reporting the bill? It does not have to go anywhere except to the floor. Vote aye. All in favor, vote aye. All opposed, vote no. We got a bunch of proxies here. Who has the other proxies? Anybody? All right. Okay, the clerk will close the vote. Ayes 11-0-0. Okay, thank you all very much for being here. I hope you've enjoyed your 4 hours and 10 minutes. The meeting will be adjourned.